You are carrying, in your pocket or purse, one of the most powerful surveillance and evidence-gathering tools ever invented. It is also a device that, during any routine interaction with law enforcement, can transform you from a free citizen on your way to a suspect in custody with shocking speed. You might think you have nothing to hide. You might believe your rights are clearly defined, but in the digital age, the legal landscape has shifted beneath our feet, and the smartphone, your constant companion, has become the central piece of evidence in countless criminal investigations and the key that police can use to unlock your private life, often with the full blessing of the courts. I'm not here to scare you with theories. I'm here to explain in stark legal and practical detail how the combination of technology, outdated laws, and subtle psychological pressures makes your phone a police magnet. Understanding this isn't about guilt or innocence. It's about knowing how the system actually works, so you can navigate it with your rights intact. The foundational shift, from physical papers to digital life. To understand the present, we must look at the past. The Fourth Amendment to the U.S. Constitution protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. For centuries, the concept of papers was relatively straightforward: letters, diaries, ledgers stored in a desk or a trunk. The Supreme Court, in landmark cases, established that the Fourth Amendment protects people, not places. This means your reasonable expectation of privacy is paramount. The critical legal concept here is the search warrant. Generally, for police to search a private space like your home or your physical belongings, they need a warrant issued by a neutral judge based on probable cause, a fair probability that contraband or evidence of a crime will be found. This is the bedrock of our privacy rights. Your smartphone is not merely a modern paper. It is, as the Supreme Court itself recognized in the landmark 2014 case Riley v. California, a digital repository of the entirety of an individual's private life. Chief Justice Roberts, writing for a unanimous court, stated, "Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life." The term cell phone is itself misleading shorthand. Many of these devices are in fact mini-computers that also happen to have the capacity to be used as a telephone. They could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, maps, or newspapers. This recognition was a victory for digital privacy. Riley held that police generally need a warrant to search the contents of a cell phone seized from an individual during an arrest. Before this, police routinely scoured phones incident to arrest, as they might empty a suspect's pockets. The court rightly saw the profound difference in scale and intimacy. But here is where the crucial, and for many, misleading narrative begins. The headline, "Supreme Court says warrants needed for cell phones," creates a false sense of security. The reality is far more complex and perilous. The warrant requirement in Riley is just one gate, and there are numerous other paths, both legal and psychological, that lead straight to the data on your device. The police magnet isn't just the phone itself, it's the immense gravitational pull of the data it contains and the legal exceptions that allow access to it. The consent exception, the most common and dangerous gateway. The single most common way police access your phone is also the simplest. You let them. This falls under the consent exception to the warrant requirement. If you voluntarily consent to a search, the police do not need probable cause or a warrant. This sounds straightforward. Just say no, but the interaction is rarely that simple. The request for your phone or its password is almost never presented as, "I demand to search your phone." It is couched in friendly, cooperative, and seemingly reasonable language. The social engineering approach. "Hey, if you've got nothing to hide, just let me take a quick look and we can clear this up and get you on your way." This preys on the natural desire to appear helpful and end an uncomfortable situation. It implies that refusal is an admission of guilt. The presumptive ask, "Mind if I see your phone?" while already holding out a hand. The pressure to comply with authority is immense. The bait and switch. You're stopped for a minor traffic violation, a broken taillight. The officer asks for your license and registration, then casually says, "And your phone too, please." The seamless transition from a lawful request to an invasive one can cause confusion. Crucially, the law only requires that consent be voluntary under the totality of the circumstances. Courts look at factors like the officer's tone. Was it coercive? The setting? Were you surrounded on a dark road? And your own state. Were you young, nervous, intimidated? An officer does not have to inform you that you have the right to refuse. Your silence or mumbled assent, even under pressure, is often ruled as valid consent. Once you unlock the phone or hand it over, you have potentially waived your Fourth Amendment rights for that device. They can look through photos, messages, emails, app data. They can connect it to a forensic tool that extracts a deep, hidden trove of data. And evidence found this way is almost always admissible. The magnet's pull begins with your own hand. The search incident to lawful arrest. Beyond the phone in your hand, Riley placed limits here, but the exception still exists. If you are lawfully arrested, police can still search your person and the area within your immediate control, the grabbable area, to ensure officer safety, looking for weapons, and to prevent the destruction of evidence. While they can't search the digital contents of the phone without a warrant post, they can still physically seize and inventory the phone itself as part of your personal effects. Once in police custody, the phone is logged. This is critical. The police now have physical control of your digital life. They can then apply for a warrant to search it, and while they wait, they may take steps to prevent it from being remotely wiped, like placing it in a Faraday bag. The arrest, even for something minor, is the trigger that turns the magnet on. Furthermore, what you are doing with the phone at the moment of arrest matters. If you are actively texting or holding the phone, an officer might argue they saw evidence in plain view, another exception, on the screen. A photo, a message snippet. If they reasonably believe you are about to destroy evidence, e.g., throw it or smash it, they can seize it to prevent that. The arrest creates a dynamic situation where exceptions can blossom. Border search exception. The Constitution at the edge. At the international border, including airports processing international flights, the normal rules of the Fourth Amendment are drastically diminished. The government's interest in protecting the sovereignty of the nation and intercepting contraband is deemed so compelling that searches at the border are considered reasonable simply by virtue of where they occur. This means that at a U.S. port of entry, Customs and Border Protection, CBP officers can, with no suspicion whatsoever, ask you to unlock your electronic devices, phone, laptop, tablet, and conduct a manual search of their contents. They can scroll through your photos, read your messages, look at your social media, and browsing history. If they find something suspicious, they can detain the device for a more invasive forensic examination, sometimes for weeks or months. While there is some legal debate and recent court challenges requiring reasonable suspicion for more advanced forensic searches, the basic manual search remains largely unchallenged. For the traveler, the choice is stark and stressful. Comply with the search or risk being denied entry, detained, or having your essential device seized indefinitely. The border is a zone where the police magnet operates at its maximum, legally approved strength. Exigent circumstances and emergency doctrines. The digital ticking clock. This exception applies when police believe there is an immediate threat to life or safety, or that evidence is imminently going to be destroyed. In the digital context, this could be invoked in a kidnapping case where police believe a victim's location might be in a phone, or in a scenario where they believe an accomplice, aware of an arrest, is about to remotely wipe a device. The scope of this exception is fact-specific and often litigated after the fact. Police will argue the circumstances were too urgent to take the time to draft a warrant affidavit and find a judge. Whether a court agrees depends on the reasonableness of their belief. This creates a powerful incentive for police to frame requests in urgent terms to bypass the warrant process. The third-party doctrine, you've already given it away. This is perhaps the most insidious and far-reaching legal concept eroding digital privacy. The third-party doctrine holds that you have no reasonable expectation of privacy in information you voluntarily surrender to a third party. If you give information to a bank, a utility company, or, critically, a telecommunications or internet company, you assume the risk that they will share it with the government. This 1970s-era doctrine is the legal backbone for vast amounts of surveillance that never touches your physical phone. Historical cell site location information, CSLI. Your phone constantly pings cell towers, creating a detailed record of your movements, often for years. Police can obtain these records from your carrier with a mere court order. based on specific and articulable facts, a lower standard than probable cause, or in some cases, with just a subpoena. The Supreme Court, in Carpenter v. United States, 2018, did rule that accessing 7 days or more of CSLI requires a warrant, recognizing the profound privacy implications of location tracking. However, shorter periods or other types of metadata may fall under different rules. Subscriber records. Police can easily get your name, address, billing information, and call detail records, numbers dialed and received, times, durations, from your provider. Cloud backups and server data. Your iCloud, Google Photos, or Facebook messages are stored on servers owned by third-party companies. A warrant or other legal process served on Apple, Google, or Meta can access this data, often without you ever knowing. This is a parallel track. Police don't need your locked phone if they can get its backed-up contents from the corporate server. The third-party doctrine means the magnet isn't just your phone. It's the entire digital ecosystem that your phone talks to. Your privacy is only as strong as the privacy policies and legal resistance of the corporations holding your data. Forensic tools, the key to the digital castle. Assume the police have your phone, either through consent, seizure at an arrest, or with a warrant. The lock screen is now just a speed bump. Law enforcement agencies at all levels use sophisticated mobile device forensic tools, MDFTs, like Cellebrite, Graykey, and Oxygen forensics. These tools can often bypass or crack passcodes, especially on older or less secure devices. They perform a logical extraction, accessible files, or, more intrusively, a full file system or physical extraction, a bit-for-bit copy of the phone's storage, including deleted data fragments. These tools can recover deleted texts and photos, app usage data, every time you opened Signal, Google Maps, or a banking app, location history from the device itself, more precise than cell towers, keyboard cache, which can suggest what you typed, even in encrypted apps, metadata from files, revealing when and where they were created. The existence of these tools increases the value of the phone as evidence. It's not just what you see, but the hidden digital footprint that can be resurrected, the psychological and practical pressure cooker. The legal pathways are one thing. The human experience of a police encounter is another. This is where the magnet metaphor becomes visceral. You are pulled over. Your adrenaline spikes. An authority figure is at your window. Your cognitive load is high. You are trying to be polite, to remember your rights, to assess the situation. In this state, the calm, persistent request for your phone or your password is an enormous psychological pressure. The fear of escalation. If I say no, will they arrest me? Will they tear my car apart? Will it look guilty? Is powerful. Most people are not constitutional scholars capable of coolly articulating their refusal under stress. The path of least resistance is to comply, and that is exactly what the officer is often counting on. Furthermore, in many states, obstruction or failure to comply laws can be ambiguously applied. While you have an absolute right to remain silent, Fifth Amendment, the act of refusing to unlock a phone with a biometric, fingerprint face versus a passcode is a legally murky area. Some courts have ruled that a fingerprint is a physical characteristic not protected by the Fifth Amendment, while a passcode is testimonial, you are telling the state something from your mind, and is protected. This confusion adds another layer of anxiety to the encounter. So, what can you do? Practical legal hygiene knowledge is your primary defense. Understanding the landscape allows you to make informed decisions, not panicked ones. Strengthen your digital defenses. Use a strong alphanumeric passcode, not a simple 4-digit PIN or a predictable pattern. This is your first and most important legal and technical barrier. Disable lock screen previews for messages and notifications. This prevents plain view seizures of information. Understand your biometric settings. In a high-stakes situation, consider the rapid use of lockdown modes. On iPhones, pressing the side button 5 times. On some Androids, pressing the power button, which disable biometrics and require the passcode. This can force the issue into the more protected testimonial zone. Encrypt your backups and be mindful of what you store in the cloud. Know that data on a company's server may be more vulnerable to legal process than data solely on your locked device. Regularly update your device's OS to patch forensic vulnerabilities. Master the encounter. Be calm and polite. Hostility escalates situations and gives police more justification for their actions. Know your script. If asked for your phone or password, a clear, simple, and respectful refusal is best. Officer, I do not consent to any search of my phone. I choose to exercise my Fourth Amendment rights. You do not need to explain, argue, or justify. Repeat if necessary. Invoke your right to remain silent. If the questioning moves beyond basic identification for a traffic stop, say, I am exercising my right to remain silent and wish to speak with a lawyer. Then, stop talking. This protects you from self-incrimination in all forms. Do not physically resist. If they seize your phone despite your objection, do not fight them. Your battle is in the courtroom, not the roadside. Verbally reiterate that you do not consent. Your attorney can later file a motion to suppress any evidence found from an unlawful search. The bigger picture. Question. The legal framework is playing catch-up to technology. Is the current balance between legitimate law enforcement needs and personal privacy correct? When the sum total of a person's life can be compressed into a device carried on their body, do exceptions like search incident to arrest or the third-party doctrine still make sense? Or do they grant the state too much power? Here is a question to consider, based on a real and contentious legal scenario. If police have a warrant to search a house for physical documents related to a fraud case, and they find a locked smartphone on the coffee table, should that warrant automatically allow them to search the entire contents of the phone? Or should they be required to get a separate, specific warrant detailing the digital evidence they seek? What are the dangers of either approach? Let me know your thoughts in the comments. Your phone is a miracle of modern life, but in the context of police power, it is a double-edged sword. It is a portal to your inner world, and the law has built several keys to open it. By understanding why it's a magnet, the legal exceptions, the psychological pressures, the technical vulnerabilities, you are no longer a passive subject. You become an informed citizen capable of protecting the privacies of your life in a world where they are more vulnerable than ever before. If you found this deep dive into the intersection of law, technology, and your rights valuable, please subscribe to the channel. We break down complex legal topics into clear, actionable knowledge to help you navigate the system. Your privacy may depend on what you know.